Today, I will be giving an introductory discussion on intellectual property law in Australia. Intellectual property is that branch of the law that covers rights such as patent, copyright, trademarks, designs, confidential information, and even passing off. Patents confer monopoly rights on inventors who have made something new. For an applicant to successfully obtain patent protection, they must be able to show that they satisfy the statutory requirement. The first major requirement is that the invention must be a manner of manufacture within the meaning of Section 6 of the Statute of Monopolies 1624. The High Court of Australia has interpreted this to mean that the invention belongs to a useful art as against a fine art, and that it is something of value to the country in a field of economic endeavor. The applicant must also show that the invention is new, which essentially means that the invention is different from what is in the prior art base, or that it is different from what is known to people generally skilled in the field. The invention must also be shown to possess an inventive step. An inventive step means that the invention represents an advancement over the prior art base, or over what is generally known to people skilled in the field. The invention is also required to be useful. The usefulness requirement does not entail showing that the invention will be commercially viable. All it requires is to show that the invention can perform the function it is designed to perform. The invention must also not have been secretly used before the date of application. Secret use has a grace period of up to 12 months. Generally, once the patent is granted, it subsists for a maximum period of 20 years, except in relation to pharmaceutical patent, which may have a further extension in some cases of up to 5 years. In relation to copyright, copyright protects works and subject matter other than works. Works cover literary, artistic, dramatic, and musical works. Subject matter other than works include cinematograph films, sound recordings, broadcast, and published editions. The law of copyright requires the work to be reduced into a permanent or material form, and the work is also required to be original to be eligible for protection. Originality in this context means that the work has emanated from the author. Generally, copyright protects expression and not ideas. Trademarks protect signs that are used by traders to distinguish their goods and services in the field of commerce or in the course of commerce from the goods and services of other traders. Generally, for a sign to be protected by trademark, the sign must be shown to be capable of distinguishing goods or services in trade. And being able to distinguish goods and services can be through inherent adaptability to distinguish, which means that the sign is inherently adapted to distinguish. And it is also possible to acquire adaptability to distinguish through use of the mark over a significant period of time. It is equally possible to have partial inherent adaptability to distinguish, which is more or less a combination of inherent adaptability to distinguish and adaptability to distinguish through use. Designs protect the visual appearances of goods that are new and distinctive. Generally, design protection will subsist for a period of 5 years, and it may be renewed for a further period of 5 years, making up to a maximum period of 10 years. It is important to note that trademark protection can't subsist perpetually for as long as the mark is in use. In relation to copyright, the protection exists for the life of the author in relation to works and for a further period of 70 years after the year the author died. Confidential information protects information that has been acquired in confidence. The confidentiality may arise at law or in equity. Essentially, an example of confidential information arising at law is where confidentiality has been imposed through contractual obligations. And it may also arise in equity where information has been given in circumstances where it would be unconscionable for the receiver to use the information in a way that would compromise its confidentiality. The law of passing off seeks to restrain traders from putting forward their goods or services as those of more established traders or manufacturers. And the whole essence is to prevent a situation where others may free ride on the reputation of more established business owners or manufacturers. As you will find, the law of intellectual property is an ever evolving area of the law. The law continues to respond to technological advancement and development in the field of science.